We're joined by Legal Practitioner Zikalala Attorneys, Mpumelelo Zikalala, pardon me. Mpumelelo, very good evening to you. Thank you for your time. As the preparation is underway to hear the ANC's leave to appeal, we know that the uMkhonto weSizwe party defeated the ANC in the logo dispute before the KwaZulu-Natal High Court earlier this year. What grounds of appeal can the ANC now argue?
Good evening to you, also to your viewers. I think they're going to come and say, let's look at the overall owner of the mark uMkhonto weSizwe in the name, and look at the confusion in which it's making. And now we're not fighting it because we're heading into elections, but we want to defend the legacy which is associated with the name, the history associated with the name, and we want to make sure that it remains within the African National Congress. Well, that might sound good when it comes to principle. However, the basis in which you've done that, maybe you'd be found lacking within certain quarters. Remember that when you appeal, you do not come with new information. You are simply confined to what you had applied and written down in the initial stages. So if the manner in which you've made your application or made your defense does not really suit your particular stance or what you want to protect, then unfortunately you stand to be defeated, because you would have lacked those important elements in which the court looks at when it says, let's protect the name uMkhonto weSizwe on behalf of the ANC.
So you're saying that it wouldn't be worthwhile for the ANC to appeal this matter, because we know, I mean, as you make mention, at the center of the dispute was the MK party's use of the MK logo, which the ANC claims now as its heritage and asset. What is the legal recourse in this instance without a registered trademark?
It's very limited. Remember what the ANC has stated earlier was to say, this is the potential of confusing voters. Now, May 29 has come and gone, and it was clear that the voters, it was very distinct in terms of the individual that said, we want to vote for the ANC, and the individual that said, we want to vote for the MK. So that particular line of confusion or passing off is an argument that, even though in principle it can be made, but I don't think it's going to carry much water. Maybe what they could rely on is the heritage part of it, to say, here is the heritage of the African National Congress when it comes to it being a political party, and a component of it belonging to a military wing called uMkhonto weSizwe that we do not want to confuse. However, another thing would be, which market are you then saying is going to be confused by this? Are they going to be able to identify the uMkhonto weSizwe of the ANC and the uMkhonto weSizwe of the MK party? If the answer is yes, that means that particular line or argument is not going to be something which you're going to be able to win on. Especially when you initially started drafting your papers, even though I tend to be corrected on this, you did not focus on that particular element, you focus on another thing. So when you go in an appeal, there's no new information or new facts that you might bring in. You are only confined to what we stated earlier. And if what you have stated earlier is not enough to convince the court, then unfortunately you stand to lose.
Yeah. So in trying to make sense of the technicalities of this case, what would happen in the instance that even if the ANC were to own registered trademarks for both symbols, would a question now arise about whether either mark has been used consistently as a trademark as opposed to a political slogan?
It would, because if you look at trademark laws or applicable legislation, it then even says it must fall within a certain category. So if you're going to say this line of uMkhonto weSizwe falls within the heritage categories, then they would say ANC, we are giving you those particular rights, it's going to be used within particular folio. However, if we're looking at political parties that can be able to contest elections and as registered by the IEC, MK party can still continue using it there. That would mean that the win for the ANC is not going to be a complete one, because I think what the ANC is looking for is to say, we want the logo and the name to belong to the ANC entirely. We do not want to be bogged down by technicalities that says MK is going to belong to the ANC in this particular category and belong to another political party in another category. And it would have been made a bit more sense to then come back and say, let's refine our fight to what we're looking for, so that you can able to come back and be number one in all those factors. Rather than taking this on appeal, is there a need for a new application which is going to look into all categories that are there and all disciplines that are there, and not only to historical side or political parties, just to make sure that when we win this particular matter, if they do win, you win it in its entirety, and don't get a half-baked win which will only guarantee a name or a slogan belonging to you only through a historical context and nothing else.
And very lastly, would you say that this appeal would be a worthwhile exercise for the ANC?
Well, if they say, as the SG of the ANC stated, they want to be seen as being in the correct side of history, then yes. But legally speaking, I think there's a bit of work that needed to be done. If you looked at the judgment and how the judges of the KZN division crafted it, they were very clear in terms of the basis and the framework in which they looked at. And they simply said, this is the law as we know it. We've applied your facts to the law, and unfortunately, they do not favor you. So you have two options. Either go back and make sure that you have redrafted it and make sure that you cover all the loopholes that you identify, or you continue limping with the hope that maybe they're going to come to a different conclusion. But I think let's give them an opportunity to tomorrow to state their case and see if they have something which is new, which is different, or a different perspective in which they employ the court to look at the matter in.
Very well. Thank you so much for weighing in on the discussion.